All right, I know we have some of y'all still coming in, but feel free to just kind of get settled. I'm just going to read a little intro here. Good afternoon. Thanks everyone for joining us today. My name is Jay Leader, and my role today is going to help facilitate this webinar. So if you have any questions during the presentation, please type your question into the chat box, or you can use the Q&A tab as well, and I can help pass the question along to the presenters today. Most of you are probably already familiar with Standpoint, but for those who aren't as familiar, just a little bit about us. Standpoint is a statewide organization. We are a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to systems professionals who work with survivors. We do this by facilitating trainings and answering calls to our action line. Examples of trainings we have are our annual new laws throughout the state of Minnesota, monthly webinars for advocates such as this one, and other trainings by request. Our action line is answered Monday through Friday from 9 a.m. to 4 p.m. And it's through our action line that our attorneys provide legal advice to survivors, and our advocates connect callers with resources, safety plan, listen, and help callers identify options and next steps. This webinar is being recorded, and you can check it out afterwards on Standpoint's YouTube page, and the link will also be emailed out to Standpoint's Legal Advocates listserv after the webinar. And for today's presentation, I'll share in the chat box a link to the PowerPoint if you'd like to follow along with us. And we have our two presenters today. We have Beth Assell, who joined the Standpoint team as staff attorney in October 2020, sorry. Beth graduated from law school at Hamline University, and directly after graduation, clerked in juvenile court in Hennepin County. Most recently, she worked as a staff attorney at Central Minnesota Legal Services for 6 years. At CMLS, Beth provided direct representation and legal advice in the fields of family law, orders for protection, harassment restraining orders, and criminal expungement. She also partnered with the Domestic Abuse Service Center to represent victims of sexual and domestic violence and strengthen the capacity of advocates working in these fields. Beth previously worked as a full-time volunteer with Lutheran Volunteer Corps and AmeriCorps, and brings to Standpoint a lifelong passion for advocacy and helping others. And we have Nikki Kelly as well. Nikki has worked in the sexual and domestic violence advocacy field since 2012. She has experience providing crisis intervention, safety planning, medical and legal advocacy, and other supportive services to victim survivors from a variety of demographic populations. Nikki also has experience coordinating multidisciplinary teams, developing programs, and training advocates. Prior to her advocacy work, Nikki served in the United States Air Force. She graduated from Argosy University, majoring in psychology, and holds a Master of Science degree in forensic psychology with specializations in victimology, family violence, and sex offender behavior and treatment from Walden University. Nikki is a member of both the Salute and Psi Chi Honor Societies. So now I'm going to put that PowerPoint for everyone in the chat, the link you can kind of follow along. And I'm going to pass it off to our wonderful presenters today, Nikki and Beth.
Good afternoon, everyone. Thank you so much for joining us. Thank you, Jay, for that wonderful introduction. We're hoping that you're here to learn about providing advocacy in family court. If you're not, we hope you'll stay and learn about it anyways. Jay did a great job of explaining what Standpoint is, so I won't take too much time on this slide, but just remind you that we used to be known as the Battered Women's Legal Advocacy Project, but we did change our name a few years ago to better reflect our services and the individuals that we serve. We are currently 5 attorneys, 7 advocates, doing everything that we can to support you and your clients all throughout the state. We do not have an income requirement, so our services are free, and we don't do an intake process when you call our action line or text us or email us Monday through Friday, 9 to 4. We do have a few training objectives that we hope you'll keep in mind as we're going through this. We'd like to start and hopefully increase recognition that abuse oftentimes does not end post-separation, especially when the victim and the abuser have children. Victims can benefit from advocacy through all facets of the court system, including family court. And so we hope that you will keep that in mind. We'd also like to help you develop a familiarity with the family court system using a sample custody or divorce case action. We have developed a case map that we're going to show you in a moment, and hopefully that'll help guide our conversation today. This should demonstrate the steps a client may encounter as they proceed through a court case, but we do want to add in a little caveat that while this is what may happen, it's not guaranteed that it's going to happen this way. And we're going to talk about some of those exceptions that could pop up. And that's why it makes family law so much fun. And we're also going to identify the ways that advocates can empower and support their clients through family court while continuing to advocate for the safety and the best interests of the children. I will take a note or a moment to note that because we are limited on time, we cannot cover all topics such as OFPs, child protection, third-party actions, including grandparents or adoptions. However, we do have some of those topics are available through our YouTube page. We have webinars there that cover those topics if you're interested in those. So I encourage you to visit our YouTube page under Standpoint and take a look at those topics if they are relevant to you. So, family court, piece of cake, right? Simple. Well, maybe it's not a piece of cake in that sense, but it is layered. There's a lot that goes into that umbrella term family court, and that can include orders for protection, dissolution, or what we refer to as divorce. It can include legal separation, parenting time visitation, child support, custody when a marriage hasn't occurred, parentage or paternity, and visitation by third parties such as grandparents, adult siblings, maybe other individuals that have a stake in that custody claim or that visitation claim. We're going to go over quickly just some glossary of terms because you have access to the PowerPoint. This is available to you, but just so we're all on the same page with the language that we're going to use today. We may talk about a complaint. That's the document that describes what the initiating party wants. The plaintiff is often called the initiating party. And that could be money, some type of relief. It could be they want a divorce, they want custody. You know, it could be a lot of things. And why they believe they're entitled to that. We will also be discussing an FENE or financial early neutral evaluation. We'll talk about an evidentiary hearing. That's the trial setting where information and documents are presented. You may be familiar with that in the context of orders for protection and harassment restraining orders. So we'll talk about how that might differ in family court, like custody and divorce settings compared to OFP and HRO hearings. We'll talk about exhibits that might be used in an evidentiary hearing. Talk about the jurisdiction. That's where which court can decide the case. We're hoping to get into motions and the distinction between them and complaints and petitions. OP, if we use that term, means opposing party, sometimes also known as the respondent. So we can jump over to that term. That's the individual that must respond to the legal action, or hopefully will respond to it. Jumping back up to the top of the second column, we have petition. It's a civil pleading filed to initiate a court action. And the petitioner is the person who's filing that or who's initiating that. I'm going to skip respondent because I just talked about that. You've got an SENE or social early neutral evaluation. We'll talk more about that. A summons or a legal document notifying the named person, that OP, that respondent, that there's an action being initiated against them or that involves them that they need to respond to. And then you might have witnesses that we'll talk about in the context of an evidentiary hearing. Beth, do you want to add anything to this?
No, that was great. I think the one thing I was going to add is that in the context of family court, I think the only time you'll see complaint is when you're starting a paternity case. So complaint to initiate a paternity action. Otherwise, for like custody, divorces, you're mostly going to see that petition.
Child support.
Child support. Yeah, that makes sense. To me, they're kind of the same thing. I have no idea why paternity is different, but it is. So just something to note that for paternity, it's a complaint.
Okay. The other thing I will note is there is a distinction between petitions and motions. Petition is always written and initiates the legal matter, whereas a motion might be submitted or is submitted into an existing case, and it could be in writing or it could be orally. It could be, in an evidentiary hearing or another type of hearing where counsel gets up and says, I make a motion to dismiss. That counts as an oral motion. All right, so I promised a case map. Ta-da! I think there needs to be more fanfare on this, really. This is going to be a little bit overwhelming. What we're going to do is take it piece by piece, but this is what might happen in family court. And I need to stress that word might, because there's always exceptions. There's always unique case factors that could change this ever so slightly. But this is essentially what we're going to walk you through of what may happen in a divorce or custody case and how it might progress.
Yeah, I think like Nikki was saying, we do our best to cover maybe how things are supposed to go or how they can go, but part of family law that I talk to people a lot about is how much discretion judges have, right? They have a lot of discretion over decisions they make and how they run their courtrooms. And so sometimes the answer can depend on which county you're in or which judge you're assigned to or how your judge is feeling that day, right? Necessarily how they want to run things. But this is just kind of the basics of how these cases can go. So first, the journey begins. Your client is starting a divorce or starting a custody action or responding to one. And so that the first steps for that would be where required information is gathered and then paperwork is drafted. And so we just have some kind of basic notes up at the top is that if this is a divorce action that you're supporting a client through, is one thing to note is that Minnesota is a no fault divorce state. So it's certainly not a state where you have to have a specific reason that you want to get divorced. You don't have to prove that there's infidelity. You don't have to prove that there's an abuse. That's part of the case, but it doesn't have to be your reason for wanting the divorce. You just have to state that there's been irreconcilable differences. And you also don't need both parties to agree. I think one thing I've heard a lot from callers and clients I've worked with is he or she talking about the other party, they won't agree. They would never give me a divorce. They would never agree to this. And that certainly makes it easier, but there's no need for that, for them to agree. So I would always say that they certainly don't have to make the process easy. They can fight things along the way and say they don't agree with the terms of the divorce, but they cannot stop you from getting divorced. If one party wants it, that's enough. You also don't need a reason to file for custody other than you have the legal relationship. I think I've heard from some callers where they feel like the other parents are abusive. They file to establish custody and parenting time. And the person who, the mother, feels like they should be able to get it dismissed because the opposing party is so clearly not a fit parent. But unfortunately, it doesn't work that way. If either of these actions are started, one person gets to decide to start them and you're kind of just along for the ride, responding and trying to negotiate the terms or get the final terms that best suit you and are best for your kids. So in terms of how we phrase it as required information, but we can maybe think of it as ideal information. What information before you even hop into these court actions is helpful to have? And when you think about divorces, where all your assets and debts are going to be divided, it's incredibly helpful if your client is able to collect things like social security numbers, financial statements like their own pay stubs of the other party tax documents, property record, copies of bills so they can prove household expenses and debts, and some relevant reports. This is one reason why we encourage you to encourage collection of important documents during that safety planning process, or maybe part of that pre-separation, pre-custody, pre-divorce planning process. It's just when they have access to it, if there's a way to safely gather them, safely make copies, it's going to make life easier when they're in that case and they have to prove, for example, in a divorce, what are our debts and assets? Or in a custody case, what's the income of both parties so we can calculate child support? But I would also stress that if your client does not know this information, if they come to you and say, I really want child support, but I don't know what he's making. He's never told me. Or I really want to get divorced, but she won't tell me what's in our retirement accounts and she keeps the bank statements from me. That should not dissuade them from filing whatever court action they need to file for themselves. There's ways during the action to try and compel this information from the other party. This is just a good first step if they're able to safely do so. And just in general, we're going to go into the paperwork more later, but the paperwork that if your party is the initiating party or the one responding, it'll really kind of vary what they need to fill out according to the legal action, but generally a notice of the action itself, like the underlying divorce or custody, and then their support for the requested claim. Okay, so a little bit more about what to file. You could even think of this in terms of what your client might be served with or what they might serve the other party with and what to respond. And so if you are starting an action, you're looking at more at a summons, which we went over on that glossary page, and petition, or summons and complaint, depending on what kind of action it is. So a summons and complaint if it's a paternity action, or a summons and petition if it's custody or divorce. And then for those types of actions, the action can start as joint petitions. Joint petitions could be in a custody case or in a divorce case. And basically that is where both parties are coming together saying, we agree that this divorce is happening, or we agree that this custody action is happening, and we completely agree on all terms. Here's what legal custody is going to look like: physical custody, parenting time, child support. We're filling out this paperwork together. We're both signing it. We're just asking the judge to approve it. That's starting as completely a joint action. I think great if that can happen, but it's not going to be as likely in situations where domestic violence is a dynamic, or even if it does happen in those dynamics, it may not be an agreement that your client completely feels is safe or that's in their best interest. It may be something that they feel they were compelled to sign. But just wanted you all to be aware that they can start as joint. But this is also a situation where if your client is coming to you and saying, I know he'll never sign, I know he'll never agree, what do I do? That's okay. They don't have to agree. They can also start these actions, for example, a divorce, as a contested proceeding. And that's where they serve them with just, here's my summons and petition for divorce. Here's what I want from it. If you want something different, feel free to respond, but I'm starting this. And then to file in response, let's say your client is served with a custody action. They should file an answer and counter petition. That would apply to both a custody and divorce action. I think the most important thing is that if your client comes to you and they've been served with an action, it can be really jarring to be served with a divorce, or it can be really jarring to be served with a custody action from someone who's been abusive to you, maybe hasn't been part of the child's life. I think the biggest thing to advise them on is it's really important to not ignore it. These actions don't go away just because you ignore it. It is important to read it and understand what they're asking for, and realize just because they're asking for it doesn't mean it's going to happen. They can ask for ridiculous things and no one's going to stop them, but that you can respond and you can have your say. Okay, so just some keynotes about custody that I think most people will be aware, but we just wanted to kind of touch base with this, that we're talking a lot about a custody action, and that's where one parent, generally the father, will file in court a summons and petition to officially establish his court-ordered custody rights and his court-ordered parenting time schedule. For unmarried parents, where a child is born outside of the marriage, the mother, who is not married at the time of the child's birth, is the sole physical and legal custodian until a court order states otherwise. And that's true even if dad is paying child support, if dad signed a recognition of parentage, or dad is seeing the child. But if the parties do sign that recognition of parentage, that document signed usually at birth, usually in the hospital, not always, but it's just a 2-pager saying we agree that dad's the legal father, and they give up their rights to genetic testing and a paternity trial. That establishes some rights. It's the right to ask for child support. It's the right for him to file for custody and parenting time without first establishing paternity, and the right also to seek custody and parenting time through an order for protection. father's name on a birth certificate alone does not establish that legal relationship. I would say for people that it's usually a sign that there's a recognition of parentage. It's a good kind of indication that they signed a recognition of parentage. But the only way to know for sure if a recognition of parentage is signed is to submit a request to the Department of Health. There's an official request form. You send it in, pay $8. If there is one on file, they'll mail it to you. If there isn't one, they'll send a letter saying they don't have it. One thing we're not touching on in this webinar is a mother who has custody by default like this. How do they prove that right? How do they get their child back if father, instead of filing a custody action, decides to take the law into his own hands and just keep the child? Not touching on that today, but we are touching on that in July in a webinar on that exact topic. So stay tuned. And just one other kind of note about a common question that comes up is that I think my understanding from a lot of callers is that they're understanding the law is that they have to be physically separated or legally separated before a custody action started or a divorce is started. And that is not true. Those actions can be started when parties are living together, even a divorce. And there is an action called a legal separation in Minnesota, but that is more, I think of it more as not something you do in prep for a divorce, but it's more an alternative to a divorce. It is still where you go through a process of filing paper and you decide all issues, you divide your assets and your debts and custody and parenting time, but at the end of it, you're still married. And if you want to get a divorce, you kind of start all over. I would think of it more for people who want that separation, but for some reason, religious or otherwise, need to still stay married. So when people call me and ask if legal separation is a good idea, I tell them unless they have that pretty serious circumstance that would mean they still have to be married, that it's better for them to pursue a divorce. And when we talk about custody in Minnesota, there's two kinds. Legal custody has nothing to do with where the child lives. It has to do with major decision making. And the major decisions, how we look at it here, is major decisions about their schooling, their religion, and their major medical decisions. And physical custody is more about their routine, daily care and control, where they're going to live, where they're going to be their home base. But even, and those two types of custody can either be sole, so vested in one parent, or joint, shared between the two. We kind of go into later how that's decided, sole or joint, but just the basics, like Nikki noted at the bottom, joint doesn't necessarily mean 50-50. So if it is joint physical custody, that doesn't mean the child's necessarily doing like a week on, week off schedule. It just means that their care is kind of structured between two households. And at the same time, sole physical custody doesn't mean that the other parent doesn't have any time. Even with these two things addressed, the court is still gonna address that third separate issue of parenting time, which is more, okay, we have these custody labels, but what's the actual day-to-day schedule? How's the transitions? What's vacation? What's holidays? That's a whole nother issue. That's good.
Yeah, so we will speak more about custody in a moment. Just keep in mind that we will continue that in this webinar. So thinking about preparing the paperwork, filing the paperwork, perhaps responding to the paperwork, let's talk about some of those opportunities for advocacy that come from those first few steps of the journey. You as advocates can assist your client with collecting that required information. Beth mentioned maybe reaching out to the Department of Health for a recognition of parentage. So you could potentially help give them access to that form. Maybe you have funding that could help pay that $8 for it if they need that assistance. You know, be creative here of how you can assist them. And it may just be giving them a computer and a printer so that they can do it, or maybe a postage stamp so they can mail it, you know, snail mail. Providing that internet access or storing those documents. If they're in that safety planning process and they haven't left yet, but they're building towards it, maybe you can be a point where they can kind of take some of those documents out of the home, bring them to a place where you can store them or keep copies for them and be that secure place for their safety. Think about ways that you can help them identify information that they need and how to request it. You know, if they need medical records, if they need financial records, maybe you can facilitate conversations with the bank by giving them access to a phone and supporting them through that phone call to get bank records. Obviously, we're hoping that you can also give them some education about their options. You know, abusers, as many of us know, are really good at painting a very skewed picture. Oftentimes, what they tell their victim survivors is what is in their benefit, not necessarily what's best for the kids or best for the victim. So they might threaten, if you do this, this will happen. Educate them, tell them, no, that's not true. Like Beth mentioned, there's a lot of things that can be put in a petition. You know, an abuser could ask for the moon and stars. That doesn't mean that the court is going to grant them the moon and the stars. Just because they ask for everything doesn't mean they'll get that. So give them that education and help them understand that they have options. You know, when we're talking about joint custody, you know, it's not always every other weekend, like Beth mentioned. There's other options. One of the things that I have found helpful as a resource when it comes specifically to parenting time is custodyexchange.com. That's with an X, not an EX in the website. They've got a lot of different parenting time schedules depicted on there. So it's a great place to start just for understanding that this every other weekend or week on, week off isn't the only option out there. There's more that they can decide and choose, and it kind of opens that door for some of those options. As advocates, we can certainly assist them with drafting pro se forms. If they've pulled them off the website, it's not much different than filling out a petition for an order for protection. So we could assist with that, support through that. I will tell you, some of that assistance could just be offering to print it and create copies, because the pros say if they're doing a contested divorce form, so if you're doing a dissolution with children petition, that's almost 50 pages. That's a lot of paper for a victim survivor that they may not be able to afford it. They may not have the printer ink. If you can help with that, just those small things are very significant. And provide that emotional support. Do what you do best. Don't leave them hanging just because they're not in a criminal case. I do want to add, definitely help them seek legal advice before they make any major decisions. As Beth might jump in here and scream at the top of her lungs, it is harder to change an order after something has been ordered than before. Yes, there is a thing about modification that we're going to talk about later.
Yeah.
But get it right the first time.
Well, I do touch on that, Nikki. It looks like, would you mind typing? Oh, are you able to type into the chat when you're screen sharing?
I can't, no.
Okay, I can. It's just custodyexchange.com.
Yes.
Okay, I'll type it in. So, I hope that's right. I hope that's right. If it's not, somebody let me know and I'll fix it.
Yeah, it's the word custody, CUSTODY, the letter X, change, CHANGE.com.
Perfect. Okay. So yes, I would agree with Nikki that one of the biggest advocacy opportunities is helping a client just seek legal advice before they make any big decisions, because they are going to get pressure. If there's contact between them and the abuser, they're going to get pressure, they're going to get threats, they're going to get legal advice from the abuser about what's going to happen. A lot of it's not true. And it is exactly true that once you agree on these custody labels and once you agree on a parenting time schedule, it's not impossible to change, but it's difficult. It's difficult, especially if it's not issues you brought up the first time. It can be harder. And I know people have really good reasons. Like I've heard a caller describe it as like when you're on an airplane and you have to put on your oxygen mask before you can help others. And she said, I'm agreeing to what he wants and getting out and then changing it, because that's me putting my oxygen mask on first. And it makes so much sense when you put it that way. But I would still, the best people can encourage their clients to try and just upfront, not just agree to terms that they don't think are in the best interest. See if there's ways to support them to go through these cases while advocating for their interest. We did have a question basically, are there any legal benefits to go through the process of legal separation, such as would it protect you from if your abuser ran out and ran up the debt? Really good question. And I guess, yeah, I mean, I think there can be a benefit in that sense, in that you are dividing your debts, you're dividing your assets, you're dividing things. My main point is that really, if what your client is after is ending that relationship, terminating their relationship with this person, getting finality, and they don't have a reason to pursue a legal separation, like a religious reason that they can't get divorced, or I suppose you could do a legal separation if you really thought reconciliation was possible down the road, they are going through all of the work and stress and emotions of a divorce through that legal separation, and they're still married. And if they wanted to get divorced after that, they have to go through that whole process again. So it's more just thinking with that. I think some people maybe have the impression, and I mean callers, just like various callers I've had the impression that legal separation, that sounds easy. Can we just get, I need a breather. Can we get a legal separation? And unfortunately, it's just not how it works here.
Yeah, I run into that with a lot of clients that I've worked with. The parties separate, the abuser goes out, runs up the debt.
Yeah.
That can all be resolved within the action, whether it's a custody or a dissolution action, that can be resolved within that, and they can be ordered to actually take responsibility for those, even though they incurred them when the parties were technically married. I do want to cycle back. We were talking about get that legal advice or encourage them to get that legal advice. Keep in mind, there's lots of attorneys that offer free consultations. Take advantage of those or encourage clients to take advantage of those. Just get multiple perspectives on the case. And we mentioned it at the beginning, we've got an action line, and we have a wonderful Beth that will answer those phone calls and give that legal advice for free to victim survivors that need it.
Absolutely.
All right, so let's talk about service. Now that you've got the paperwork completed, what's the next step? Usually it's being served or serving the other party. Now that summons and petition, or the summons and complaint, that first initial action for a legal matter has to be done by somebody else. The initiating party cannot do that service. So that service in hand by someone other than the petitioner could be a good friend, could be a process server, ideally the sheriff. And we'll talk a little bit in a moment about that. I do not recommend that it ever be you, the advocate, doing this service. There's a wide variety of reasons that we don't want you filling out an affidavit of service that goes in a court file and makes you a witness. And we can talk all about that later if needed. Just not a good idea when there's all these other options. So with the sheriff, that's my ideal option, because if your client can't afford it, I had to help someone do service recently. That was about $100 that the sheriff charged to do civil service. Your client can ask the court for informa pauperis, that fee waiver. If that's granted, the sheriff will honor that as well and do service for free. Process servers don't always honor that. So this is one of those moments where, as we talked about in the beginning, our map is what could be, and this is one of those slight deviations. In this, the way we've set up the process map, you're doing the service and then you're filing it with court. But in order to get that informa pauperis waiver, you would have to file with the court first, everything but the certificate of service. Once you've been granted that fee waiver, and I mean your client, once your client's been granted that fee waiver, then they would conduct service and then file that certificate of service with the court. So it does get a little bit kind of back and forth here. After that, everything else can be served by mail if desired. There is also e-service that's an option. That's actually a pretty convenient service that the court has set up. That's through the court's website. If the other party is not available, can't be found, then you might look into service by alternative means. And that might be publishing it in the paper like we've done with OFPs. And Beth, you're going to jump in here with pocket filings, this really weird Minnesota concept.
Yeah, so basically, yeah, I think this is also some calls we get of like, I got served with papers, but I called the courthouse and they have no record of it. So this can't be valid, right? So this isn't real, is it? And it's just something to be aware of, is especially if the other side has an attorney and maybe they're kind of savvy, one thing they can do is draft up the paperwork and have you served. And they're not going to file it yet. They're going to have that in your hand and they're just going to kind of sit and wait and see what the other party does. And so if you get a court bound paperwork and it doesn't have a court file number on it, that can be a sign that that's maybe what's occurred. It's something to help them check in MINCs on our online court record system to see, just search by their name, see if there is a case open. But what they could potentially be doing is seeing if the person served is going to ignore it, going to try and pretend it just goes away. But as long as they've had a notice and an opportunity to appear, which is all presumed by having that paperwork handed to them, if they wait long enough, they could potentially just file the action as a default. We'll kind of get into that later, but say, I served her, she didn't respond, didn't reach out to me. Court, here's all my proof I did that. Here's the proof I waited the amount of time. Just please grant this order. So those can be dangerous. It's part of the reason you don't want your client to just sit on things and assume it's just going to go away. That it can be easier to stick your head in the sand, but it's not a legally sound option.
Now, the other way I've heard of this playing out is party is served, party responds, and they work everything out before the court even knows about it. They have a settlement, and basically the first time the court hears about it is the parties going in and say, Your Honor, we're all done. We just need you to sign off on this.
Absolutely.
Minnesota is one of the few states that I'm aware of that does that, and that's called a pocket filing.
Yeah. And just a notice on the service voucher, and it means SAMs is what they call it sometimes. It's just another thing. If your client says, I can't get divorced because I can't find him, I have no idea where she's living, don't let that stop them either. As long as you can show the court that there's just personal service can't be made, but you can think of an address where a notice may reasonably get to them. Be creative. Do you know where they work? Do you know where their aunt lives? Do you know where their mom and dad live? Somewhere you can get that notice out and you can tell the court, I know that's his mom's address. She'll give him his mail. He had notice. So that we have a question. Do you suggest that a respondent not respond to the pocket filing then, or how should they proceed if this happens? I think we get into that on another slide, but basically, if you're served with something, even if it's not filed, you should still respond within the appropriate amount of time. Go ahead.
I was going to say the exception to that would be if they don't disagree with the legal action. I mean, if they agree with everything, they don't have to respond. But how likely is that going to happen in the cases we work with? Probably not. So absolutely encourage them to respond, encourage them to get legal advice around it, make sure they understand it and know their options.
And your response would be like, for example, if you're served with a divorce petition, but it's not filed, you have 30 days to respond, filling out your answer and counter petition and getting that back. So serve your response into the hands of the attorney. For example, if the petitioner in that case is represented by an attorney, and that could be mailed to them, emailed to them, whatever. Yeah, doesn't mean that you as a respondent have to be the one to file and bring it to court in the first place, but you are asserting that you are participating and asserting your position by answering in time.
Mm-hmm. So filing and response times are complicated. That's why we have a crazy watch. And it should all be stated on the summons, and just keep in mind that the summons are really good about listing out these time frames. It does include holidays, does not include the first day or the day of service. So the clock starts that next day after an individual has been served, but weekends and holidays are included in this count. It's just a straight go on the calendar, count the days out, and that's when you have to have it returned. And depending upon what the response is, can change what you need to turn in and when you need to turn it in. So if it's, just an answer and a summons, or an answer to a summons, that's 30 days. An answer to a summons, a petition for custody, that's 21 days. Like we said earlier, if the respondent agrees, they don't need to do anything. They can just let it go through. It'll be likely ordered as a default judgment. If they do not agree, then they must, even if they don't agree with a piece of it, if there's a single piece that they disagree with, they really do need to file a response or risk that default where the other party gets everything that they're requesting. The response needs to go to the opposing party and or their attorney if they're represented. If they have an attorney, it goes to the attorney. If they don't, it needs to go to the other party and the court. If they are responding to an initial petition, so they've been served with a petition for divorce or custody, I think Beth and I would both say they should file it with the court, get rid of this pocket filing mess. That way there's no concerns or games about it. Make sure the court is aware of it. And I have a note here about a mail example that if the papers are served by mail, or if you're going to be responding by mail, you need to add that 3 days. So if an emotion would have to be postmarked at least 24 days before a hearing. So you need to add 3 days to all of the timelines on the first 4 bullets.
Okay, so when you have, let's say your client is the one who's filing, where do you file? What are some general guidelines? For a divorce, you just have to have lived in Minnesota for 6 months. For Minnesota, on the other hand, for a custody action, for Minnesota to have what's called jurisdiction over your child, over the custody action, meaning they're the appropriate state to make the decision. You have to have lived in Minnesota, made it your home state, which in the law is that it's been the child's home for 6 consecutive months. Exceptions are orders for protection, which don't have those residency restrictions or emergency jurisdiction, which we're not really going to go into today. Raina and I did do a jurisdiction webinar that's on our YouTube if anyone's super interested in that topic. But then it's not only jurisdiction. So is Minnesota the right state? Is family court the right setting? But it's also venue. And venue is more, think of like residence. Which county do I file this in? Where's the appropriate courthouse to file this in? Divorce filed in the place of residence of either spouse, right? So if your client lives in Hennepin, but their spouse is now staying in Anoka, it could technically be filed in either county. Child custody, on the other hand, should be filed where the child lives or where the child may be found. Usually going to be the same thing, but that's how it's phrased in the statute. So I think a big thing for custody actions, or not a big thing, but something I've seen is that usually it's the dad filing for custody rights because they don't have it under the law. Even if the child lives in a different county, they may just file in their own county because it's more convenient and they don't know and no one's going to stop them right out. But if you do notice that with your clients, it's a custody action and it's not where your client lives with the child, they can ask for that to be switched to their county if they want to make sure it's in the appropriate venue, is what that'd be called. And when you do file, just touching on the service, not only service, so giving it to the other party, but filing, the way you let the court know, that the other party's been served, that you're starting this action and they've had that notice, that official notice by personal service. You file a certificate of service or an affidavit of service along with the required paperwork. And whoever is the one who handed over that paperwork for you is the one who signs that affidavit or certificate of service. And then we have a question, can jurisdiction be changed if the petitioner has stayed at home? The respondent poses a severe danger to the petitioner. So I would say that, I want to make sure I'm answering this correctly, that basically if you have a safe at home, right, it's always going to be that St. Paul address, but they can still file in the county where they live or where their spouse lives, for example, if it's a divorce. It's not so much, I mean, let's say your client has a safe at home and they're not the first ones to file and their spouse files in their own county, and that would be appropriate. Like if it's not appropriate, like for example, it's a custody case and that's not where the child lives, you can ask to change it. If it's a divorce and it could go either way, I mean, you could certainly still ask to change the venue. You can make an argument that one venue is just going to be more appropriate because we'll have sometimes it's, ease of access to witnesses and evidence about the child, things like doctors and, doctors, daycare, things like that. That can be a successful argument. So I think it's worth making it. Maybe would kind of depend on the facts of the case, how far apart those two counties are. I know at least for some clients with a safe at home, they're like, I don't want him to know what county I'm living in. He doesn't even know that information right now. Maybe in that case, it's safest to let's file where he lives. You have every reason to file there because he lives there. It's a divorce, that's totally fine. And then you keep your location even more confidential, not even letting on a county where you're living right now.
Yeah, I think the other thing to think about with venue and safe at home, if that occurs where they've filed in the county that you live in and you're not comfortable having it venued there, you can certainly, like Beth was saying, make that request to change venue based on safety factors, things like that. The court may be a little more reluctant. A lot of hearings are now by Zoom, and so you're not likely to go into the courthouse, but you certainly can make the request to change venue. Jurisdiction, remember, is probably more state.
Yeah.
All right. So when you're ready to file it with the court, this is one of the reasons that individuals may not necessarily file right away with the court, because there is a filing fee unless there's a fee waiver that has been granted. And the filing fees vary by county. We have listed the court's website where you can look up your specific county and find out what the filing fees are. There's some great drop-down menus. You'd be looking for either dissolution or custody in those drop-down menus. But just for some comparison purposes, I pulled Hennepin and Ramsey counties filing fees just so you could kind of get a sense of what that could look like. And this does apply to both parties. So the petitioner and the respondent have to pay these same filing fees.
Yeah, that is something I've heard a lot. No, he can file for divorce because I'm gonna let him pay the filing fee. Unfortunately, yeah, both parties, anytime you file something, you have to pay this initial fee. And then if you are paying, each motion will be an additional fee. So if your client qualifies for a fee waiver, low income, has public assistance, represented by legal aid, it's really good to get that fee waiver on file so they won't be deterred from filing anything. Thanks, Jay.
All right, so we had a little note on there to complete a parent education course after filing. This is particularly important when there's a custody dispute or parenting time visitation question in front of the court. And the statute does actually state that in those cases, parents must attend a parenting education class. From my recent research, the courses are offered in person, online, maybe a hybrid version. And from what I found, they range 4 to 8 hours in length. But what I will point out is that the courses that are approved vary by county to county in Minnesota. So you want to go to that hyperlink in the middle of the page here, find out which courses are approved in the county. The other thing is not all courses will accept the informa pauperis or the fee waiver, but many do. So just because there's an expense doesn't mean that it's necessarily a deterrent. We'll also point out that sometimes children are required to participate. I believe if they're over 6, some courses will ask for their participation. And according to the statute, not necessarily practice, this is one of those little asterisk moments. Parties are supposed to complete the course within 30 days of the first filing. And they definitely have to begin it within 30 days of that first filing. And prior to what's called the initial case management conference, which we're going to talk about. And once they have completed it, that certificate of completion must be filed with the court.
And this is something this is the rule. So we're teaching you, but in practice, some judges may never even ask about the course. They may forget, right? That it's in their order that a party's supposed to do it, but this is just best practice. And we just have a couple questions. Sorry, were you done, Nikki?
Yeah.
Okay. One was, if you want to file IFP, do you file the IFP first, or can you file the IFP along with the petition? Really good question. I wish you could just file the IFP alone. I think that would make life a lot easier, but part of what the statute says is that when you're seeking that fee waiver, that informa pauperis or that IFP, the court not only has to determine, do you qualify income-wise, but they also have to make a determination, is your action not frivolous in nature? And they can only make that determination if you look at your paperwork, like your divorce petition, your custody response, whatever it may be. So you have to file it all together, unfortunately. And then someone's just specifying, do you have to pay if you file a response? Yes. So anytime either party files their first piece of paperwork into the case, they're going to be hit with that filing fee that Nikki showed, and that's going to be their initial filing fee for either initiating action or responding. And thereafter, there's some filings like a letter that will be free, but a motion will be like $50. So really ideal to get that fee waiver if they at all qualify.
I'll actually go back a screen or try to go back a screen. Yeah, motions could be $75 if you need to do a motion to modify custody, for example. There's a filing fee for that.
Yeah. And then a question of, do we basically, do we recommend that we check, parents check with the court to see if a specific education course is acceptable? And I think you will see, I think it does vary a little bit from county to county, but like I'm looking right now, like for example, the 8th Judicial District lists currently approved courses, and then they split it between in-person and online courses. And there's some that you're going to see across the board, like the U of M Parents Forever course, that's bridging parental conflict offered by the Bridging Center. Those are usually going to be accepted. Yeah, I certainly think if your client was maybe going out of the norm, it wouldn't hurt to check, but I think in most cases, the court's gonna. The parenting education course is not something that your client should get, that should be a major source of stress or that they should get caught up on. It's just kind of a box they have to check as they go through this process. Yeah.
And Beth, I'm going to anticipate a question here. There is that time range for courses. Do judges, in your experience, object or tend to frown on parents who do the minimum amount, or do they?
No.
Okay. And no gold stars to those that do the extra time, you know, the 8-hour ones?
No, I would say it was rare to see someone actually file their certificate of completion. I still recommend it, but it didn't always happen. I've had a judge get mad at a respondent one time for not doing it because he was just bugging her otherwise. So she brought up, and by the way, you didn't do your parenting course. I would say no. If your client does one of these approved courses, no matter if it's, as long as it's approved and they file a certificate of service, they're going to be way ahead of most people.
Yeah. So when we're thinking about what we can do to support our clients in this stage of the journey, if they're the petitioner, assist with service, but not you. Do not do service. If you run into issues where you're the only one that can do service, please call us first and we'll brainstorm ideas, because I really don't like that idea. If they're the respondent, maybe provide them some education regarding their options again. You know, we've talked about how joint custody, and I know I'm repeating myself on this one, but that's really important for clients to understand. Help them with drafting those pro se forms, provide the space and the tools. And by tools, that may not just be printer, ink, and paper, but you know, if they don't qualify for Informa Paupers, is there anything your agency can do to help support them? Maybe you can help them with the parent education course, or help advocate with some of those courses to try to get that fee waived or work things out. Giving them the technology and the space to do that, provide that emotional support, please. You know, those are huge. Don't underestimate your power and your support.
And we just had a comment from an advocate that they usually suggest their participants do the U of M course, which is the Parents Forever, as it's generally acceptable throughout the state. I think there's lots of good ones, but I totally agree. That's the one where I would just sign up my clients, because they take IFP. It's completely free. It's online, super, just straightforward. Anyway, this page is on ICMCs, which is the start of like our acronyms in family court, I think, which stands for Initial Case Management Conference. believe in the vast majority of counties are holding ICMCs now. And this is going to be the very first hearing in your divorce or custody case. You can use this, this hyperlink we have here to search specific to county to see if your county offers one. I don't think every single county does, but I was kind of looking through that list. It looks like a lot of them have started. And if yours is a county that does an ICMC, that is the very first hearing. And the main point is to meet your judge, talk about what the contested issues are, talk about potential resolution options and what the next steps are going to be. No final decisions should be made unless there's an agreement. Agreements can be recorded and put into a court order, but if there's no agreements, they should not be hearing contested issues, should not be hearing motions at this point. I would say in practice, some judges may kind of stretch this and put the pressure on. If a party comes in, I haven't seen my kid in 5 months. What can we do about that? How about we do this? You know, they can kind of try and work out an agreement, maybe depending on the disposition of the judge, but just something to prep your client for, especially if you're familiar with your judges, but it shouldn't be that way. And really the case after this ICMC, after this initial case management conference, can branch off in a couple different ways. Parties can agree to participate in some kind of alternative dispute resolution, which is ADR. It's basically options for them to meet with neutral professionals and try and work out their issues early on in the case with that help of professionals. It can branch off that way. In some cases, the responding party may not file anything and may not show up at the hearing. That case could branch off to become a default. Like they had the chance, they didn't come, so let's just finalize things how I suggested in my petition. Some cases, ADR, alternative dispute resolution, is not going to be appropriate, but there's issues that need to be addressed immediately. Your next step could be scheduling what's called a temporary motion to try and get a temporary order while that case is pending. That would be your second type of hearing. Basically, if you're going to do a temporary motion, you want some kind of order in place where you're going through the case. That can't be heard at the ICMC, unfortunately, but you can use that setting to say, don't want to mediate. I just want to set up a temporary parenting time schedule while we get through this. Temporary motions can address a lot of things, but for example, is temporary custody and parenting time, temporary child support, temporary division of assets, even who's going to live in the house while the case is pending. For those types of temporary motions, the court doesn't have to issue detailed findings. They still have to let both parties be heard, but they can just kind of issue an order based on what they think is best and then change it when it comes to that final order. I think shockingly, Nikki, we're probably going to run low on time, so I'll just leave it at that for now. And yep, I can work on getting that link to the U of M course. Absolutely, I will put that in the chat. And just touching on motions again, what I mean by that when we're talking about, in this case, a temporary motion for temporary relief. Motion is just your formal request for the court to issue an order or rule on something. And if it's happening the way the rules of practice say it's supposed to happen, you are filing an official notice of motion and motion telling the party what you're asking for and what date it's going to be heard. And then it's accompanied by an affidavit, a sworn statement saying why you want that relief and why it's appropriate. And motions can be, like I said, temporary, for a temporary relief while a case is pending, or to modify when a case is done. And motions can also be ex parte, or emergency. Ex parte, just like the sense that it is in an OFP. It's one-sided at the time of relief because it's such an emergency that you don't even have time to give notice to the other party. Okay, I think I'm done on that unless anything to add. Okay. In default, this is just kind of when we talked about the ICMC, and it can go all kinds of different ways. It's real fact dependent, but default is one of those options. And really, default technically means that someone's been served, so they had that notice and an opportunity to appear, but they choose not to do so. For divorce, it's 30 days is their official time period to respond. Custody is 21. I know some callers I've talked to have thought as soon as that 30 days is up, something magical happens, right? It's up, it's over. Why hasn't anything happened? totally get that. And I wish it worked that way, but unfortunately it's not as clean as people expect it to be. For example, if someone doesn't respond, let's say you file for divorce or your client files for divorce and they don't respond. Oh, good, they're not going to participate. But then the court sets an ICMC and you go. If the other party shows up, most courts will see that as, okay, he's here, he's participating. This is moving forward. It'll be enough. We still recommend that you file that official answer to establish your rights and that you're participating, but just kind of a note to people that it's not always super clean. But if no answer and no appearance, it is the potential for a default, just asking the court to grant everything that you're asking for without their other party's participation. This will require the filing of additional paperwork, and it will require a hearing if children are involved and there's no attorneys on the case.
So just to be super clear here, one of the things as advocates we can prep our clients to understand is that even though you have that response time frame, the court is built in a grace period, kind of like you get with, bills and other things in life. The court understands life happens, and so they will build that in. So even if that response time period has lapsed, they're going to give them a few extra days, weeks to respond before they'll consider a default.
Yep. Yeah, can be extremely frustrating for some people, but it's just the reality.
Yeah. All right, so another branch that Beth talked about was settlement process, or alternative dispute resolution, for short, ADR. And I'm going to get to explain some of that. So ADR usually involves ancillary family court professionals. These are individuals that could be appointed when there's issues. They might be individuals that the parties hire and engage in the case. These are often social workers, psychologists, attorneys, or just general lay people that have been hired into a particular profession. Their goal is to obtain information about both parents, possibly about the children if it's a custody issue, and then provide recommendations to the court. Unfortunately, they may have limited training regarding domestic abuse. I can rant about that another time, but I just want you to know that, and know that these people that your clients are working with are agents of the family court. They're not friends. They are not advocates for your client or their kids necessarily. So family court professionals can be guardian ad litem or GAL, a custody evaluator or custody investigator, a mediator, a parenting time expediter, PTE, parenting consultant, not to be confused with a parenting coach, both of which go by PC, and a therapist. We're going to talk a little bit more about some of these as we go through these slides. So when we're thinking about a guardian ad litem, I know there's a lot of information on this slide. It's important to understand that their role is to advocate for the child's best interests. That may not always align with what the child is stating that they want. It happens where they meet with the child and child says, I want to live with dad because dad buys me candy and lets me stay up all night and doesn't make me do my homework. Is that really in the child's best interest? Probably not. So it's possible that the guardian ad litem may make recommendations to the court that are contrary to what the child wants. So with that in mind, we can jump over to the box on the right and those limits. And I really want to point out a guardian ad litem is not an attorney for the child. That's something that parents can hire if they choose to. But it's very rare to have that happen, but they really aren't an advocate or representative of the child. They are there for the child's best interest. They are kind of the court's extended arm to figure things out in a contested custody case. They do have a lot of rights. I'm going to go to the center on the screen. They do have a lot of rights of access and notification. They are going to be a major part of the court hearing. All right, so a custody evaluator, kind of keeping with the comparison, their role is a little bit different than a guardian ad litem. Their role as a custody evaluator is to conduct an independent investigation assessing the child's best interests. They're going to present written reports, but they are statutorily governed. Again, they are not any of those other ancillary family court professionals. They are certainly not an attorney for the child, but they do still have similar rights to information and access to information and notice about all proceedings in the court case. Beth, I've got a quick note here about explaining mandatory versus permissive appointment with custody evaluators. Is that something you want to tackle, or should I?
Yeah, I think if I put that in the wrong place, I think I meant that for guardians.
Okay.
Right, so a guardian is usually, parties can certainly have an opinion on if it's appropriate or not, but ultimately the court's going to make that decision to appoint a guardian ad litem. And the statute divides it up into a couple ways. Like basically there's what's called permissive appointments where, you know, if it would be helpful, we'll appoint a guardian to the family court case. And then there's mandatory appointments where if there's allegations of abuse or neglect to a child, it is supposed to be a mandatory appointment. Doesn't always work that way, but it's supposed to.
Mm-hmm.
To say that in practice, guardians are super limited, low budget. There's never going to be a permissive appointment. I think it has to be
Ordered by the court.
It has to be ordered by the court in a pretty serious mandatory situation, right?
Yeah.
And then custody evaluators, I think you see that more by agreement of the parties because custody evaluators also come in counties that don't have a court services, which is most of them. It's going to be a private custody evaluator, which is going to come at a humongous expense. They're so expensive. And so that's something to keep in mind. And we're having a question, does a relevant family court professional use depend on the particular jurisdiction? You know, like guardians, the law is, you know, it's, what's I'm going to say similar. It's the same across the state, right? It's still that mandatory or permissive. It's more just, unfortunately, kind of what I see it come down to sometimes is just the resources of the county. If they have guardians to appoint, custody evaluators could be in any jurisdiction. Kind of just depends on the judge and if that's what the parties want to agree to, if the parties can afford it. We have a question: at what age can a child tell the judge who he or she wants to live with? Will the judge grant their wish? Really good question because I hear that a lot. We're going to touch on the best interest factors at the end, but any custody or parenting time determination has to take into account what's called the statutory best interest factors, 12 factors that the court has to consider. One of them is the reasonable preference of the child if they're mature enough to have a reasonable preference. So I would say the preference of the child is always one among many. There's no magic age. It's just kind of a determination of how mature they are, if their opinion is their own sound mind and not being influenced by a parent. It's never just that that's going to be just what the child says is what goes, but I would say as the child gets older and older, there's even case law that like a 16 or 17-year-old, their preference becomes an overwhelming consideration for the court. So 15, yeah, I would say you're getting there. The court's still going to look at all the factors, but the older they get, I think it's more just realizing there's only so much the family court can still do.
Yeah.
And custody evaluator is generally like a private person who provides the service and hired by the parties.
But remember, not their friend. Just because the parties hire that individual, they're still going to stay neutral. They are still acting to inform the court, not a friend, not an advocate.
Yeah, and we had a question about who pays for it. I think that kind of depends. Like there are a few counties like Hennepin that has a family court services where they have their court employees and there's a fee scale and it's very set. Otherwise, it can be, what the statute says is the court shall order all or part of the cost to be paid by either or both parties based on their ability to pay. And there is a statute that if a party is incapable of paying, those costs have to be borne by the county welfare agency or the Department of Court Services that performs the investigation. Some counties aren't going to have that court services arm. So I think if one party just can't afford it, the court's not likely to order it. Sometimes you'll see the wealthier party, sometimes the abuser, offer to pay for it all. Can be a good thing, can come with red flags, especially if they're willing to pay for only one particular evaluator. So always really help your client do their research before agreeing to this private custody evaluator.
All right, so other ancillary family court professionals, this is kind of the big ADR trio. And this is just a summary of them. You have the mediator. Their job is to try to help the parties resolve specific case issues, and they cannot issue binding orders. So this is, the parties would meet at a location. Sometimes the mediator can put them in separate rooms for safety reasons. Not all mediators will do that. Not all mediators, like we've said earlier, not all ancillary family court professionals have a lot of training about domestic violence. So there is a power dynamic there that we need to be considerate of. But some will put them in separate rooms and help facilitate that. So for some cases, mediation can be helpful towards reaching a settlement in the divorce or custody case, but it's certainly not appropriate for all victim survivors. And we really want to really caution against that. There's also a parenting time expediter. They're kind of a step up from a mediator. Their role is to interpret and clarify an existing order. They are appointed by court order. That can happen with or without the party's consent. One party can say, I'm okay with it, and the other party can say, I'm not comfortable, and a judge can order it anyways. They are governed by a Minnesota statute, but I will note that the duration of their appointment varies. Some expediters will include a contract with the court order. Usually that contract will mirror the court order, but sometimes there's some differences there that can create some issues. An expediter can issue binding decisions on the parties. So that's something to keep in mind, that, you know, if they're not well trained in the dynamics of domestic abuse, an abuser can be very charming, charismatic, manipulate the expediter. A bad decision could come out, and then your client is left with a bill and with an order that's potentially problematic, and their only recourse is to pay a filing fee to go to court and challenge that binding decision. But sometimes it can help. I've worked with a lot of clients that have parenting expediters, mediators, parenting consultants. Sometimes it's effective, sometimes it's not. But that really comes down to the client's level of education and their support. If they have enough support and can advocate for themselves, that seems to be the most influential factor. The parenting time expediter does have access to the child and information as well. Mediators do not. And then we go over to the cowboys of family law, the parenting consultants. All of these professionals, these three professionals are, could be post-order, could be a mediator, could be pre-order. Parenting time expediter is usually post-order, parenting consultant is post-order, meaning that the court has issued an order and they understand and recognize that the parties are likely going to continue to have conflict and issues that need help with resolution. So if a parenting time expediter is not appointed, the parties could agree to a parenting consultant, but this appointment is only via agreement or stipulation by the parties. And it has to be a contract that the parties enter into. One of the things that I really want to stress is parenting consultants are not statutorily governed. They're a product of contract law.
Yep.
That carries with it a whole ball of concerns and issues that have to be navigated. And the duration of the appointment can also vary. I've seen it as short as 2 years. I've seen it ordered until the kids are mature and reach the age of 18, which if you've got a bad PC and you now have a contract that says you can never get rid of me. Yeah, really, this is one of those moments where you really want to encourage your clients to get legal advice before they do this.
Yeah.
That parenting consultant can issue binding decisions. They have access to the children and to information, including filings, case events, etc.
Yeah, I think that's really, really good descriptions. You are exactly right. This expediter and consultant, you're mostly going to see, okay, we got through the whole case. We have our order. These are the people who are going to help us deal with it if we don't want to come back. And you'll see it, the judge is like, I don't want to see you guys again. Just bring it to an expediter. Just something to know about the expediter too is that even though the judge can make that decision, a party can object and the court's not supposed to appoint one if a party can't afford it or if they claim to be a victim of abuse. So those are, I think if they're not interested in having an expediter, things to make sure your client can raise
So I know this is a lot of information on this slide. I apologize. I tried to organize it in a way that could be helpful. We'll go through the keywords of it. When your client is working with ancillary family court professionals, it's important for you as the advocate to know what the client wants for custody and parenting time and work with them to communicate that information. Help the client to be specific. If the custody evaluator doesn't ask something, encourage your client to let the custody evaluator know those things, or the other ancillary family court professional. I may say custody evaluator a lot. I mean ADR professional, family court professional. Teach the client to do all of these things I have listed on the second bullet. Focus on the kids. Like Beth said at the beginning, Minnesota is a no-fault state. I mean, honestly, if the parties had an affair, court doesn't care. And I don't know about your experience, but in my experience, they care about domestic abuse only as much as it affects the kids and as much as you can articulate that it has impacted the kids. I've had judges draw the line and say, he did that to you, you've left the relationship, so I don't see an issue anymore. Now, I strongly disagree with that perspective, but I just want you to know that that's the current party line that I'm hearing sometimes. So clients really need to connect it to the kids. Keep it focused on how it impacts the children. Teach your client how to do that. We've got some slides coming up in a moment that give some examples of that. Also help them think about the strengths and weaknesses. Help them acknowledge theirs and then reframe their weaknesses. Help them anticipate the other parent's points and then be able to address them. Especially when you're speaking with a custody evaluator, and we'll talk about how that can happen. Make sure that they're treating conversations with the other parent as though it's being recorded or preserved somehow. Know that other parent, this is a contested case, that other parent wants their goals. They want the sun and the moon. Mm-hmm. Go into that with that expectation. It's also important to help your client understand and go into it with the assumption that the evaluator doesn't know anything, hasn't reviewed anything. Most don't read the case file before they meet with individuals because it's a lot of prep work to do that, so they choose not to. When you're talking about gathering supporting information, that includes police reports, 911 records, maybe even the kids' report cards, just anything that shows what is best for them. We're still connecting it to the kids. On number 6, we're talking about assisting them to get copies of all mental health records. That's including their own, making sure that you're reading it through with them or that you're checking in with them to make sure that they understand it. If there's recommendations in there, talk to them about those recommendations. Help them understand what's positive and negative in those mental health records. Talk about ways to handle negative information, help them work through that plan. Maybe even support the client when they're talking to their therapist, because they're going to want to talk to their therapist about what they might say when the custody evaluator calls. So help them have that conversation and prepare their therapist to speak with the custody evaluator. One of the other things we as advocates can do is offer to practice with the client things to say when they're in therapy to remind the therapist of particular strengths as a parent. That's that prep work that we can help with. Definitely encourage them to follow the recommendations. Show that you took that feedback, show the court that you heard what was said. If they have an attorney, help them work with their attorney to address those recommendations. As advocates, remind your clients, I'm moving on to number 7, remind them to treat that evaluator with courtesy. This is a court professional, not a friend, not an advocate, but definitely a professional that deserves that courtesy. Our clients need to make sure they're returning phone calls. We can't ignore it, just like we can't ignore paperwork that we've been served with. Definitely need to respond quickly, promptly. I had a case recently where a child protection worker called, the parent wasn't able to call back right away, but it did not go well because the child protection worker had the expectation that they were going to get a response within an hour, not 4 hours later. And that escalated things unnecessarily. So whenever possible, they need to return those calls very quickly. No, do not miss appointments. You know, it's important for your clients to make their appointments or communicate if there's delays. They can ask the evaluator what they should expect. That's a great question to ask, and encourage your client to ask those. Encourage your client to also talk about how to discuss the visit with the kids. If you have a custody evaluator coming into the home or another ancillary family court professional coming into the home, ask that question early. What should I say to the kids about this? What do you want me to say to the kids? That's a great question to give to your clients. We also encourage them to keep a journal, you know, talking about any issues or incidents that come up with the ancillary family court professional, but keep it factual, keep your emotions out of it in case it needs to become a piece of evidence for an evidentiary hearing. As advocates, sometimes I've been able to sit with clients through some of these meetings. So I've been able to encourage them during meetings or telephone calls. It's okay to take a break. They can ask for that break. They can ask for a moment to collect themselves. You can remind them of that just the same as I do when I'm sitting in interviews with prosecutor or law enforcement. We can support them emotionally as they're going through this very difficult process.
Okay. And I think those same tips apply as your clients working through, if they decide they want to go through alternative dispute resolution. Again, that can be ordered. I guess it can be before a court case or any time during the process, but generally right after that ICMC, one option is mediation. But just note that mediation, some courts may not see it this way, but it can be your client's option and they can opt out of it if they have been a victim of domestic abuse from the other party. You mind going on to the other one?
Yeah, I just want to highlight here that, you know, the statute does acknowledge that, and it can be dangerous. So we want to be careful.
And I think, yeah, it can be, for some, that alternative dispute resolution can end a case early. It can be favorable terms. It can be a reality check to the other party, but it should be an empowered decision that they make, that's something they want to participate in. And just a note that there's also a type of alternative dispute resolution called an early neutral evaluation. Again, most counties will offer this. You can go to that same link that we had before that kind of told you if your county had an ICMC. It would also tell you if your county sponsors what's called an ENE, early neutral evaluation process. Those can both be financial and social. Your clients can do both, one or none. But the difference between that and mediation is it's more, it's court sponsored. So there's going to be a fee schedule. There's going to be a roster of individuals who agree to abide by that fee schedule. And instead of mediation, which is more a facilitative process where they kind of facilitate communication, it's more going to be a process where the parties take turn communicating about the core of the issue and the evaluator gives their opinion on the topic. It can be more affordable and it can be a really useful tool for some parties as long as they kind of understand going in the pros and cons. It is non-binding and confidential.
All right, so within that phase of the journey, advocates, we can assist them with drafting their notes and their statements. They can put together notes before they meet with an evaluator. They can have some things that they want the evaluator to know because we're assuming that the evaluator doesn't know anything about the case, right? And absolutely provide that emotional support. I have had ancillary family court professionals tell me I am not allowed as an advocate in the process. So that's another piece that we as advocates can do is maybe a little bit of community education, a little bit of networking with our family court professionals in our communities, let them know what we do, how we do it, and build that foundation before it even becomes an issue so that when you have a victim survivor that wants an advocate sitting in mediation and providing that emotional support, you're able to do that with very little conflict from the mediator. So we mentioned how do you connect it to the kids? Now, your client may say something like, Chris always puts me down. However, if you can teach them to say, every day when Chris comes home from work, Chris shouted at me, "You're too dumb to put dinner on the table on time. I don't know why I put up with you." The twins were there most of the time. During the last 2 months, they've started calling me dumb. You see that connection to the kids. Another example, Pat drank all weekend versus Pat drank 2 cases of beer every weekend. Pat was too out of it to spend much time with the kids. Sometimes they asked Pat to take them to the park, but after a while, they stopped bothering to ask. Again, it's bringing that back to the kids and the impact on them or the changes in their behavior. The other thing we mentioned is help your client anticipate the other parent's points and address them. So one example, I think that Shannon might tell the evaluator, "I'm crazy because I take antipsychotic drugs." I will tell the evaluator I take perfenazine to help me think straight. Since I started taking it 1 year ago, I cope much better. My psychiatrist has reduced my dose to the minimum possible and plans to end it completely after the stress of this divorce is over. You've anticipated that and addressed it. The second example, my suicide attempt last year actually turned my life around. I started going to a support group for domestic violence victims when I got out of the hospital. I left my partner after I realized the kids and I didn't have to live in constant fear he would actually shoot the pistol he pointed at us. Our lives are now peaceful and calm. One of the things I like most about this second example is not only have you identified the other parent's points, but you've also been able to kind of point out some of the problems with the other parent. I like it when you can do a 2-for-1.
Okay, so trial preparation and trial, and not all cases, family law cases will go to a trial. It's just like in order for protection, a lot of them will settle. Either parties, it's a default. They settle on their own or through attorneys, or they go to alternative dispute resolution and either resolve the case or kind of whittle down the issues. If cases don't resolve, they will get set for a trial. For a lot of courts, they will set that pretrial conference first. And prepping for pretrial, I know we're kind of out of, we're really low on time, Nikki, so I'm just going to try and kind of fly through this. But basically, if it seems like the case is going to go to trial, the process of discovery may come up. That can be formal, which is a process of exchanging documents that's very formal and regulated by statutes and has deadlines in place, or it can be informal, just a request between the parties to exchange documents that they need to prepare for trial. It's usually done when attorneys are on the case, but your client can do that. They can ask for documents if it's relevant to the case and there's something they need. I think at that point, it's more just useful to ask them to reach out for some legal advice about their deadlines, the methods, and the best way of doing so. But just so you all know that that is an option, discovery during the case to try and get information that's relevant to the case, what they need to prove their point. I know you make this much. I need to see your pay stubs. When you're going to that pretrial conference, the main point of that is to inform the judge what issues the parties still disagree on, so the judge can anticipate what may be argued at a trial, makes it clear what the parties do not expect to argue and what they've agreed on, so kind of how the issues have been narrowed. And at that pretrial conference, you're also going to see the court usually set the trial dates, set deadlines for exchanging exhibits and witness lists. And it also can be a time set aside for the parties, especially if there's attorneys on board, to try and negotiate and move forward in good faith and finalize the case. If that's not all possible, it can eventually be set for that trial.
As we talked about earlier, custody and parenting time.
Yeah, so maybe we should just kind of, the next one's just touching on again is that, especially in these custody cases, the main thing the courts can be deciding is custody and parenting time. There has to be, custody needs to be joint or sole. Your parenting time schedule must be specific. It can be restricted if there's concerns for safety, and it has to be based on the best interest of the child. I do think our next few slides are best interest of the child factors. Maybe we could just kind of,
Yep.
This is something parties might just our participants might just have to go back and read, but these are the factors that the court has to make decisions on. Basically, they're looking at the child's needs, if they have any special needs, again, the reasonable preference of the child if they're old enough, whether domestic abuse has occurred, the physical, mental, and chemical health issues of a parent, if that impacts the child, the history and nature of the parent's participation in providing care, the willingness and ability of each parent going forward to provide ongoing care, the effect on the child's well-being and development of changes to homeschool and community, the effect of ongoing relationships between the child and each parent, siblings, and other significant person in the child's life, the benefit of the child in maximizing parenting time and the detriment to the child in limiting, the most confusing factor. 11, except in cases in which domestic abuse has occurred, the disposition of each parent to support the child's relationship with the other parent, sometimes called the friendly parent provision, where if the court doesn't find that domestic abuse has occurred, they have to look at how well each parent is supporting the other parent in their relationship with the child. And 12 is similar, the willingness and ability of the parents to cooperate in rearing the child and sharing information.
So things that the courts, when they're looking at those best interest factors, Beth, I apologize, this one was for you.
Oh, it's okay. Just basically when the court is the one making this decision, when they're issuing a trial order, or even when an evaluator is giving their feedback, they're supposed to look at all those factors and make a detailed finding on each factor. So the trial order will list, their order after trial will list each factor and how they found in favor of either party. They can't use one factor to the exclusion of all others. They kind of have to be all weighted evenly. Considered factors may be interrelated, but there still has to be that separate finding on each. And the best interest of the child is to promote the child's health and growth and development through safe, stable, and nurturing relationships between the child and both parents. So there is that presumption in law that parents are both capable of being nurturing, and there's different ways of loving and nurturing a child.
I will jump in here and say we have some resources at the end of this presentation. One of those resources is the court's perspective on the child's health, growth, and development. So that's a great thing to read through and encourage your clients to look it over as well.
Yeah, and just quickly, I already kind of went over that top part. I think the main thing here is that if your client has been a victim of domestic abuse, it's important to let the court know, because not only does it play into those best interest factors, but if the court makes a finding that a party's been a victim of domestic abuse, they have protections in place. Like they can't be forced into mediation like we discussed before. And also there's a rebuttable presumption, so kind of a starting point that can be changed, but a rebuttable presumption that joint legal and joint physical custody is not in the best interest of the child. It is in that way important to make sure that the domestic abuse is part of the record.
Mm-hmm.
Nikki, we are officially over. Should we just try and wrap up quickly, or how do you want to?
I think we can make it a few extra minutes if people don't mind.
Okay.
Yeah, when we're talking about how the courts apply those best interest factors, those 12 factors that Beth went through quickly and listed the statute, they also are going to consider the conduct of the parent that does not affect the parent's relationship with the child, or shall not consider it. I apologize. So that's what we talked about earlier. If a parent has an affair and it doesn't impact the child, they don't care.
They don't want to hear about infidelity. Yep.
Yep. Disability, if a parent is disabled, that alone does not mean that they can't have custody.
Right.
And disagreement over whether or not to have joint or sole custody, not enough for the court to care about. That alone does not mean an inability to cooperate. That's important to think about. Just because you disagree doesn't mean you can't cooperate. Joint physical custody does not require an absolute equal division of parenting time or an equal division of time. I think we've said that a couple of times, and I might say it one more for good measure at the end. And you may not consider a parent's past deployment or future deployment as a reason to impact custody and parenting time. So when we're thinking about advocacy opportunities, what I would really say is go through those best interest factors with your client, help them to take that language that we were talking about of connecting it to the kids and address each one, help them to look at their strengths under each best interest factor, help them to look at their weaknesses under each factor, and do the same thing with the other parent. help them walk through and write responses to each of those factors. That's huge. That's what the courts are looking for. Attorneys are going to be looking for that, and that can save them a lot of time and money if you're willing to sit down and help them respond to those in ways that are connected to the kids. That emotional support, the resources, the time, the copies, the printing is a huge benefit as well.
Yes.
Oops.
And the trial. So again, a lot of cases may not get to this point, but if they do, if parties can't agree on their issues are on their own, it can get set for a trial where the decision that are left is going to be in the hands of the judge. You can go to the next one, Nikki. So the big thing is trial, maybe known also as an evidentiary hearing, basically where the judge is going to be making a decision on the issues that are left that haven't been resolved by the parties. And they'll be hearing from both parties in the form of sworn testimony, witnesses, and exhibits. Couple key things. Before the trial, in most counties, the court will issue a trial order that may be before the pretrial or after that pretrial that we talked about, that provides key instructions for preparation about when and how to submit exhibits, witnesses, witness lists, etc. Really important to help your client look for that order, read it, understand it, and make sure they're meeting those deadlines. If they don't meet those deadlines, this important information could be kept out. Trials can be on all issues or just on partial issues. It can be set for one day or multiple days. And parties can represent themselves in trial. I think don't count on a continuance just to get an attorney. Some judges may allow that, but it's in their discretion, and they may say this case has gone on long enough and we're going to proceed with trial, and parties do represent themselves. In the resources, we do have a trial guide for pro se parties, people representing themselves. I think the best thing you can do to prepare for trial is the advocacy tip from before. If it's a custody case, have them prepare what they want to say and list out all the best interest factors. And just like Nikki said, underneath the factors they want the court to know through their testimony, their strengths and how that should weigh in their favor. Know that they're unlikely to receive a decision on the day of trial. Most judges will take it under advisement and have 90 days after they do so. And once the order is received, please, if you can, help your client read it, comprehend it. It can be, I think, traumatic to get it. It can be hard. It can be many pages, but it's really important to understand what's in there and what it means and what's expected of them.
And that's just proofreading it too. I mean, that order may come out, there may be a significant mistake in there that needs to be corrected, and it's better to do that as soon as it comes out rather than weeks or months down the road when it's harder to change the mistake.
Yep.
Because judges are human too.
And just a quick note on child support is that can be ordered in a divorce or a custody case. We have a joint incomes model, and so both parents' gross income is considered in the calculation. You can go to that link for the child support calculator and have your client calculate what child support may be in their case, depending on the factors like income, cost of childcare, etc.
Okay.
And then after the order, if they accept the order, the case can be complete for now. If they don't, there's a possibility of an appeal, which we're not covering today. Even after the case is complete, some things can be modified: child support, parenting time, custody. Other things are final, like a waiver of spousal maintenance, dividing assets and debts. Those are considered final. There's some exceptions to everything, but for the most part is how I would see it. And just in general, custody and parenting time can be harder to change, especially for custody. There's timing requirements, such as you have to wait a year unless there's an emergency. And if a court has made a decision, it would say you try for a modification custody and they say no, you have to wait another 2 years unless there's an emergency or the other party is really denying parenting time. And the reason we say to try and get legal advice before you agree to something important like custody is you have to not only show, that was a bad decision or the kids aren't happy with him. It's a higher standard. It's called an endangerment standard is the most common one. They are endangered in his care. Can be hard to show. Parenting time can be modified based on the best interest of the child, but also can be difficult to change if there's already been a schedule in place.
So as you're helping your client go through the trial, that's key. Provide that emotional support, go to the trial with them, be there with them through that. Post-order, provide that emotional support, those resources, referrals, personal advocacy as they need it. Let them tell you what they need and what would be helpful, but be there for them, please. Most importantly, I'm going to say this again, most importantly,
Yep.
deprivation of parental rights and kidnapping. We get the calls about that a lot.
Yep.
If a victim is afraid that their abuser will abduct the children, call us. Please, please, please call us. Do not help a victim move out of state. I meant do not help them move out of state without first speaking to a competent family law attorney. Beth, we'll take those calls.
I will.
Call back.
And that's if there's parenting time. If there is parenting time ordered, our law says you can't move out of state without an agreement or a court order. Even without parenting time, there's still risk. It's just mostly a note that please call us if a moving out of state is going to be an issue.
I don't care if there's a court order or not. You need to have legal advice.
Yep.
And most importantly, if you don't know the answer, please call us.
Yep.
We like to take your calls. We like to talk to you and help you. That's what we're here for. And we'd rather give you the right information so that you can give your client the right information than risk all of those things that we've just been talking about for the past hour and a half that could go wrong.
Yeah, and I think haven't seen any new questions pop up along the way, and I know we're about 10 minutes over, so thanks everyone for sticking with us.
Yeah, thank you so much. Here's those resources we mentioned, a lot of them. That child-focused parenting time guide is important to get a perspective of what the courts are looking for and their view on parenting time and custody.
Okay, thank you so much, everyone. Sorry, Nikki and I always go over. We should just know.
Thank
We're
you
ambitious.
so much. Thank you to Nikki and Beth. Thanks to those who joined us, and you will get the link emailed out to the listserv, and it'll be on YouTube as well for those who had to hop out a little bit early. But thank you again for joining us, and we'll see you all next month.
Thanks so much. Bye.